Happy Sunday morning. I was just had a few minutes to go over a little bit of this Bunny Boots Inc. thing. Um, the big deal is, well, we don't know exactly what he was charged with. He hasn't presented anything document wise. Caveat: I am not licensed to practice in Oregon, so I'm not giving a legal opinion on this. The the big deal, though, is what Bunny Boots was using. He believes that he was charged with trespassing in a post office, and he's citing 41 CFR 102-74.420 as allowing him to be there. That's this one right here. What's policy concerning photographs for news advertising or commercial purposes? And he's close. He's darn close. The correct statute, though, is 39 CFR 232.1, conduct on postal property. If we go down here to H5I, you have photographs for news advertising or commercial purposes. There are some slight differences between this statute and the one that he referenced. You'll notice, except as prohibited by official signs or the directions of security force personnel or other authorized personnel. That is missing from this statute. Photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings. I do believe that this when used for public meetings, a court will not look at that as just applying to auditoriums. They will look at it as applying to the entrances, lobbies, foyers, and corridors, as well as auditoriums. And you're going to ask me why, and I'm going to tell you, you can use my car on Monday, Tuesday, Wednesday, or Thursday when you pay me for it. And you're going to expect me to believe that statement, you could use my car on Monday, Tuesday, Wednesday, or Thursday when you pay me for it, means that only if you want to use it on Thursday do you have to pay me for it. That's why it doesn't work. Some other fun little parts of this, which also would apply, is conformity with signs and directions. We're in the same statute, Part D. All persons in and on property shall comply with official signs of a prohibitory or directory nature and with the directions of security force personnel or other authorized individuals. Believe it or not, when you're in a post office, you have to do what the authorized people in there tell you to do. Disturbances, this Part E here may also apply because it's very vaguely written. It may be overly vague, but I haven't looked up case law on it, so don't hold me to anything. But you notice that even if it just otherwise tends to impede or disturb the public employees in the performance of their duties, or impedes or disturbs the general public in transacting business. So if people are getting upset at you filming in there, that may be enough because of the kind of broad nature of it. Again, it may be overbroad. It may be constitutionally overbroad and be struck down if it does impact filming. And maybe it will. I can't say anything about that, but that would potentially apply. Another thing is you saying that if this 41 CFR 102-74.420, if this applies, if he's allowed to be there, then that would throw out any claims that they'd have. What he's thinking is, I'm assuming what he's thinking is, there's a federal trespass that would somehow supersede, I guess, the state trespass. And that's not entirely how it works. There are federal laws against drugs. There are state laws against drugs. You can be charged with both. If one gets thrown out, the other one does not necessarily get thrown out. A lot of times, you'll see. Well, maybe you won't see. A lot of times there are cases where a state will prosecute somebody for drugs or for murder or kidnapping or any number of other things, and due to some defect in the prosecution or a hung jury or something like that, they're unable to get a conviction. A lot of times the federal government will step in with their claims, and they will charge and try the defendant for the federal crimes. Now, most likely what these police officers did is they charged Bunny Boots with a state trespass. And it was probably criminal trespass in the second degree. I don't believe that anything in the first degree fits. It wasn't, there's nothing about a dwelling there. There was no emergence notice of trespass. He wasn't on rail yards, tracks, bridges, or rights of way that I am aware of. And he wasn't on basically condemned property. So I don't believe that he would be charged with criminal trespass in the first degree. He's most likely charged with criminal trespass in the second degree. This is probably one of the least verbose trespassing statutes I've ever seen. Implied in there, probably in the case law that I'm just too lazy to look up, there is a requirement of notice in order to make it unlawful. I can't imagine that there would not be some element of notice. You have to know you're trespassing in order for it to be criminal. In order to have the mens rea, you have to know you're not lawfully allowed to be there on the premise. So, anyway, this most likely is what he's charged with. As far as the disorderly conduct is concerned, first degree doesn't fit. There's nothing about a hazardous substance or impending fire, explosion, catastrophe, or other emergency. I mean, maybe that there's maybe case law that extends this to kids, something threatening kids. I don't know, but this doesn't seem to fit. So it'd most likely be disorderly conduct in the second degree. Again, not a very good fit, at least from the short amount that I saw and my previous knowledge of Bunny Boots. He doesn't seem like the kind of fella who would engage in threatening behavior, unless you count filming as threatening. But that seems to me like it would be a bit of an overbroad kind of reading of this. I haven't looked up case law, but so a person commits the crime of disorderly conduct in the second degree if with the intent to cause public inconvenience, annoyance, or alarm, which you could very easily argue that what Bunny Boots was doing was intending to cause public inconvenience, annoyance, or alarm. He was, with the hood, with the sunglasses, all completely legal, but also designed to attract attention, to make people think he's suspicious. I'm not faulting him for it. I'm just saying that that's a reasonable person is going to draw that conclusion. A judge is going to draw that conclusion. A jury is going to draw that conclusion. Whoever the finder of fact is, I almost guarantee you that they will say that his intent was to cause annoyance or alarm. But was it threatening behavior? I don't think it would work. He's obviously not engaging in fighting or violence or tumultuous behavior. I don't think it's threatening. I think this would be more like assault style kind of thing where, carrying around a baseball bat, maybe not making any motions that would lead it to the level of assault, but carrying around a baseball bat, telling people you're gonna bash their skulls in. That would probably, I think that would be something that you would find cases on. Not taking photos or shooting video. The only other possible thing would be if Bunny Boots had stopped on the sidewalk or something, where he was obstructing vehicular or pedestrian traffic on a public way. Again, though, that would be a question of fact. He was filming. Were there people who were having to move around him while he was stopped filming somewhere? And does it rise to the level of disorderly conduct? It doesn't seem like a very strong charge to me, but I've seen prosecutors run with stuff like this before, especially if they're trying to make an example of people and trying to run up defense fees and all that fun stuff. So anyway, that's where we're at with that. I'm not going to ramble any further. I hope you guys all have a great day. And Bunny Boots, if you ever watch this, I wish you the best of luck, and I hope you get a good lawyer, and I hope you beat this and maybe teach him a lesson about filming in public. Have a good day.